I guess so we're talking about jury trials. We haven't had a whole lot of jury trials in the context of family law.
Yeah, they're pretty rare. You don't do a
Yeah.
lot of jury trials. You don't see a lot of jury trials in family law.
Right.
They're pretty expensive,
Yeah.
and they take a long time. It takes a long time to get into a jury trial.
And there's lots of prep, lots of chaos, and lots of unknown because you don't know what the hell the jury's going to freaking do. But we do them. I mean, we've done them, and we'll continue to do them, just kind of depending on what's happening with the case. I think there's definitely some cases where it makes sense for us to do them. If the clients can afford to do them, then we're going to definitely push in that direction. We have used that strategy before and then end up getting settlements because people don't want to incur that expense. So,
Yeah, and as you can tell today, we're going to talk about jury trials in the context of family law, I think specifically child custody stuff. So welcome to the consultation. My name is Josh Floyd. This is Christina Jimenez. We are both attorneys here at Jimenez Law Firm. We practice, we have offices in West Texas, up in the DFW area. And so we're just going to shoot the breeze about some jury trials today.
yeah. So, reason why we're talking about it is because we actually recently had a jury trial, and by we I mean Floyd. But like most things,
You'll take all
I
the credit for it. Yep.
At least half of it, not all of it. I'll take half of it.
Even though you
Because
weren't
I
there
was
for
very
any of it.
integral to this process.
That attended not 1 minute of the jury trial. Yes.
So Floyd had a jury trial that he attended. I was in the background. I was like helping him.
300 miles away.
And it was fun. It was the whole process leading up to it. It was a lot. And so I guess let's just talk generally in the context of family law cases. As we were just talking about, you rarely see them, and there's several reasons for that. I think the biggest one is the expense associated with it.
It is. It's very, very, very expensive to go to jury trials. I think can we say the number?
I mean, yeah.
I think on this one, just the jury trial portion of it. So we tried it in early February.
Mm-hmm.
We're so late putting this out because there was some appeal stuff that we had to. We've actually done it before, but because of some appeal stuff that was going on, we had to wait, and so we're redoing it. But this one we tried it in February, I think, and so we started really the deep jury trial prep around mid-December, early December, and I think our client spent a little over $30,000 from December of 2022 to February 2023 on the jury trial prep. That doesn't count what he spent the year and a half or so before that we were representing him. So
Well, and I think that's honestly light. If I had to guess, most times for a jury trial, you're going to be looking at $50,000 to $100,000, and just crazy numbers. I definitely think that there are some instances where it is warranted. But most of the time, once we start having those sort of discussions with our clients and talking about pros and cons of a jury, we end up, or the clients end up deciding, no, I can't afford that, and I want to go ahead and just do it in front of the judge. What makes it so expensive?
all the work that's involved. So in this case, you said 50 and 100. So from contract to end of jury trial was about 70,000 total.
Mm-hmm.
But it's just so with a jury, you have to educate the jury a lot, and so what you could try in front of a judge in 4 to 6 hours, right? It's going to take you 2.5 days. By the time you do all the jury selections, and you have to educate the jury on the law, and you approach the jury trial much differently than you do a bench trial or a trial in front of a judge because of the lack of knowledge and having to educate the jury. And there's, just different aspects you have to play to with the jury instead of the judge. Like you have to, put on a show, make it interesting, where judges have been there, they've seen it all. You're just going to present the evidence and let the judge make a decision. But you've got to keep 12 members of the jury interested in your case, which is sometimes very difficult.
Right. And I mean, so there's what we call voir dire, however you pronounce it.
Voir dire, we're in Texas.
Yeah, voir dire. And so there's voir dire. That takes additional preparation, right? There's opening statements. There's closing arguments. There's all sorts of additional points that we have to get prepared for that we don't have to do in a bench trial. And I mean, honestly, when we're in front of a judge, the more that you try to I guess bloviate, the more pissed the judge is going to be at you. And so it's short, simple, get to the point. He knows what he needs to hear. She knows what she needs to hear. And if you try to, do any of the song and dance for the benefit of your client, a lot of times it ends up having a negative impact. Whereas in a jury trial, we're doing PowerPoints and we're doing photos and videos, and we're really trying to put on a big show because it matters to lay people because they've never done it before, right?
Right, and like I said, you got to keep them interested, right? I mean, a lot of times this stuff can be dull and boring. Sometimes it's fun, depending on the case, but the way you present it to a judge would be boring in front of a jury.
Right.
Right, and if you don't keep them interested, then they're not going to listen to what you're saying, and so it's a lot of role-playing and acting and things like that.
Prepping your witnesses, prepping your client, making sure your exhibits are 100% ready to go. There's not going to be any technical issues. It's just a whole lot of prep time. I mean, I would say for a final trial, like if I had a full day final trial, I probably prep like maybe up to like 10 hours at most in most cases. But for a jury trial,
Oh, God. 40, 50?
yeah. It takes a long, long time to make sure everything runs seamlessly. And I do think that we're probably a little bit more like heavy because I think both of us have a lot of anxiety when it comes to those scenarios, and so we want to make sure everything is perfect, everything's on point. So we spend a lot of extra time that maybe some other attorneys don't.
We don't like to lose very
Yeah,
much.
we don't like to
It
lose
hurts the
at
old heart.
all. Yeah, our egos don't deal with that very well. So I think it's expensive because of the preparation time. Another reason why we don't typically do it is because we're pretty good about consistently practicing in front of the same judges, right? And so 9 times out of 10, we know this is our judge, this is what they expect from us, this is what they expect from our clients, and we can lead our clients down that path so that we have success in that court. And it's more of a sure thing, right? Like we know what's going to happen, and if it's going to be something that's negatively going to impact our client, then we're going to maybe settle the case, or we're going to figure out a strategic way to gain an advantage in that courtroom. And with the jury, it's kind of...
You never know. It's so hit or miss.
Yeah.
And there's very limited issues that a jury can actually hear, right? And so even if you have a jury trial, you still have to have a bench trial after that to decide the issues that a jury can't decide.
Yeah. So what are the issues that a jury can decide?
So specifically in child custody cases, because that's what we're talking about here, they can decide, the appointment of joint managing, sole managing, or possessory conservatorship. Mm-hmm. They can decide who's going to have the exclusive right to designate the primary residence, and the geographical restriction.
Right.
So it's just those 3 issues. But as far as the allotment of all of those conservatorship rights and child support and medical support, visitation, all that has to go to the judge. So you still have to have 2 different trials if you have a jury trial.
Right. So I think for the context of this particular case, we just need to call Dad John, Mom Jane, John and Jane.
Those are creative names.
I thought so. And then, was it a boy and a girl? Or
A boy and a girl, yeah.
So, I don't know what we're going to call them in a second. Let's just call them the children.
The children.
Because I'm going to get confused with John and Jane and Jim and Jan.
Yeah.
It'll be a hot mess.
We'll just, incorporate them into one
Okay.
being as the children.
Very good, okay. So, in this particular case, we were representing John, Dad. And John came to us.
You don't want to switch the names and make Jane, Dad, and John?
No.
Okay.
So John came to us after he had already had his temporary hearing, right?
Kind of. After the temporary hearing was scheduled, he didn't get to have a hearing because he followed the advice of his attorney.
That's right. So we were his second attorney?
Second attorney, yes.
Okay. And it's funny because I was actually talking to this judge the other day, and he said, you know what my first rule of being a lawyer is? And I was like, what's that? And he said, don't be the second attorney. And he was like, what happens if you forget rule number 1? What's rule number 2? And he was like, see, rule number 1, don't be the second attorney. And so we were the second attorney. We didn't follow his rule. And, you know, I think sometimes there's this perception that if you're the second or third or fourth, or we've sometimes been like the sixth attorney, that it's a client problem. And I do think that sometimes that's correct.
Sometimes it is.
But I also think that there's some occasions where the client just chose poorly the first go-round. And they need somebody who's going to come in and fix that. And in this particular case, that's what needed to happen.
Yeah,
So,
and I don't know that it's necessarily the lack of ability on the other attorney, right? I mean, this attorney was an out-of-town attorney, which we always emphasize, hire an attorney that practices in that jurisdiction because we know our judges, right? And so I just think that in this case, the wrong strategy was employed because he didn't know the court, right? And it really put our guy in a bad spot.
okay, so John hires an out-of-county attorney, and it was like smack dab in the middle of COVID too, right?
It was.
And so
Smack dab.
There was.
That's a legal term, I think.
There was some issues with getting the hearing scheduled and then attending the hearing, and so his first attorney actually ended up entering into an agreement. I guess we got to back up before we get to the agreement and kind of talk about what had happened between John and Jane.
Yes.
What had happened?
They split up.
But there was more to it, Floyd.
There
It
is.
was crazy.
Yes, it was crazy. So there was some issues with mom using drugs. Actually, on the day of separation, well, before the day of separation, mom had gotten into an accident with the kids in the car. We believe that she was under the influence of marijuana at the time. And then on the day of separation, she'd been smoking weed again, and she was trying to take the kids to school. And Dad's like, no, you're not. You're not taking the kids to school. You can walk them, but you're not driving them. And so she took off a little wagon with the kids. And then next thing we know, the police were knocking on the door. She had called, reported that he'd been aggressive, he had firearms, like this whole thing. And so they made him actually leave the home. And he went to some parking lot. I want to say it was a Home Depot parking lot, but I don't know if that's really relevant. But he went to some parking lot, and he was watching on his camera, on his phone, and they had backed up a U-Haul and unloaded everything from the house into the U-Haul, and then Mom took the kids and left.
And she left too.
Colorado,
and we're in West Texas.
Texas.
Yeah.
Yeah, Texas. Yeah.
And so, and she was from Colorado. I think her family was in Colorado. So no warning to Dad. No opportunity for him to say goodbye to his kiddos. No opportunity for him to stop her from taking all of his belongings. Nothing. I mean, they're up and they're leaving, and he's watching all of this stuff on a freaking camera while the police are there at the house, basically saying you can't come back or else. It was just a really, really crappy, horrifying situation.
And he didn't even actually know where the kids were for a couple of months until he hired an attorney and I believe an investigator, and actually found out that the kids were in Colorado. Before that, he didn't have any idea where they went.
Yeah. And so he hires this attorney. By that point, I guess she had already been in Colorado for a couple of months. And this attorney says, presumptively says, she's been in Colorado. This is just a temporary hearing. And so you should just agree to let her and the children stay in Colorado. And you can have your visits, and you're going to pay child support. You're going to pay some spousal support too, right?
He did pay spousal support.
And let's just kind of put a Band-Aid on this. And so...
Yeah, so I think a deciding factor for him was, at this point we weren't having in-person trials, right? And he said that he could not litigate a custody case over Zoom, right? And so,
here's one thing. I'm going to kind of digress and talk a little bit about temporary orders here. And we've said this probably a million times on the podcast, but it is so very important that you treat your temporary orders hearing like a final hearing. And when we're prepping for temporary hearings, we're prepping for them like they're a final hearing, because typically what will happen at your final trial is the court is going to maintain the status quo. So What happens at temporary is likely going to stay the same at final unless there's some crazy circumstances that occur between temporary and final. So if you ever have an attorney that's like, oh, this is just temporary, don't worry about it, not that big of a deal, you need to run, don't walk, like get the hell out of there, because they clearly don't understand how important that process is, right? And so in this particular case, this attorney didn't, I guess, understand it, didn't care about it. I don't know what he was doing, didn't know the judge, I don't know. But they end up agreeing to let these kiddos stay in Colorado.
They did.
And then for their exchange for the visits, they were supposed to meet at a halfway point.
In New Mexico.
Yeah. And so even though his kiddos were taken to another state, he was still having to drive how many hours?
12, I think.
Round trip. I think it was like 6 hours.
Right.
Yeah.
Yeah.
So 12 hours just to get him on a weekend. And so it was just a really, really raw deal for this dad. So he comes in, he hires us, and we talk about it. And so that's one of the things that, Floyd and I do a lot is we'll do what we call case strategy meetings where and a lot of times we're very blessed because we have a couple of paralegals that have been with us 10 plus years. We have another that's been with us for nearly 5. And so we all have lots of experience in lots of different cases in front of this judge. And so we have a case strategy meeting and we kind of figure out or decide that we need to try a temporary hearing.
Yes, that's true.
So I guess at this point, what had happened is Mom had been denying visitation, right?
Yes.
And it was various things, like she was saying...
kids were sick, or she didn't have gas money, or whatever to get down there. Just one excuse after another. And he went like 2 Christmases without seeing his kids.
Yeah. And then I think there was a couple of times where he had to drive all the way to Colorado just to pick them up and bring them all the way back.
Actually, the first time he drove all the way to Colorado, and she let him see the kids in the front yard for 20 minutes.
Yeah. So we're hearing all this information, and so we say, well, why don't we file a motion to modify the temporary orders? And let's explain to this judge all of the headaches that we're having with the visitation and the fact that, he's not getting his visits, Mom's not traveling, Mom's, I think she was also, like, not letting him talk to them on the phone.
She was working under the table for cash. Yeah, there was a lot of issues.
And so we tried to modify, I think it was the visitation and the spousal support, because it was our contention, like, listen, he's having to pay all this extra money just to see his kids, and she's, not being very kind.
So I think that was the second time. The first time, I think we tried to get the kids back here to Midland.
Do we have 2 motion to modify?
We had 2 different hearings to try to change this order.
Ew. And so the first time was what?
First time we tried to get the kids back to Midland.
Okay. Because of the troubles with the visits.
Right.
Okay. And then the second time was?
The second time we were trying to modify the spousal support and exchanges, I believe.
And so both times?
Both times were a loss, yes.
Both times you lost.
I lost, yes.
Like, that wasn't a we.
I lost the battle.
We won the jury trial, and he lost the hearings. So we lost, and we were both kind of like
at a loss.
I mean, we honestly we didn't. We understood, but we didn't. And it was just very frustrating. It was very frustrating for our client because we kind of just felt like Mom was getting away.
Yeah, and we were trying to dig him out of this hole that he was put in through no fault of his own.
Yeah.
Well, bad legal advice in our opinion, right? And so he was in this, I don't know, it was tough to get out of.
Yeah, it was a bad situation, and each time we got shut down. And it was through that process that we kind of figured Judge is not going to make this mom move back. And Judge is not going to give him any relief from the visitation and the exchange provisions, and we don't know that we're going to be able to win a final if we have to go back in front of this judge just because of what he had done on those 2 hearings.
And this guy was a good dad. Like, he was heavily involved in the kids. he just got blindsided by her taking off to Colorado, but he really, really, really wanted to be with these kids.
Right. And now, to be fair, a lot of times judges are not going to be inclined to modify things at a temporary basis, right? And so that was definitely discussions that we had, that maybe it's just a temporary. Maybe it's just because these are temporary and we have a final that's coming up, and so maybe judge is just going to wait to do anything until he gets to a final. But then the question was, what if he doesn't, right? And is that a risk, John, that you want to take? And if you're going through this process, you should always kind of be having these conversations with your attorneys, right? Like, what if this happens, then that, here's the cost associated, here's the risk, here's the benefit. We had lots of those conversations with John about, do you want to do this? And I think ultimately, obviously he decided that he wanted to go in front of a jury, because he was just worried that we may not get any relief in front of this judge. So, then we get to the jury trial.
Yes.
And so, how did we present?
So we knew it was an uphill battle going in, right?
That's an understatement. We were for sure thinking that we were going to lose. Another one. And we had been very clear with our client on that, because very conservative jury. The kiddos were how old?
6 and 4, I think, something like that.
6 and 4. And so we were dealing with young kiddos. We're going up against mom. We're in a conservative county. Mom had the kids at this point in Colorado for
a year and a half, 2 years, I think.
Kiddos, for the most part, were doing good in school. There wasn't really any health concerns. There was nothing crazy like that was going on. It was just the fact that mom was alienating these kiddos from their father and the impact that has on children, right? And so, but I think that kind of took the pressure off. Like, I remember talking to you, like, the morning of the trial, and I was like, dude...
I'm always calm, cool, and collective right before a trial.
No, he was freaking panicking. And I said, there's zero expectation. You're not supposed to win this fight. Oh, this freaking case. And so you're no pressure, right? Just go in there, have fun, do what you need to do. And if you get a GEO even, that's a benefit. That's a win, right?
GEO being a geographical restriction.
Right. Or if you get the judge to make mom travel all the way to Texas for these visits, like, that's a win, right? So just go in there and have a good time, and whatever happens. So
and the funny thing is I always tell my clients when we're prepping for hearings, I'm like, look, this is kind of my strategy now. This may change 5 times before the hearing, right? Because it's every time we come up with something, we're thinking about talking about strategy, and we may change. We changed our strategy the morning of jury trial. Do you remember that?
I do.
I was sitting at Starbucks with Julie.
Right.
We were prepping. And we changed strategy. I'm like, oh, y'all sure? Is this the way we want to go?
What was that issue?
The recordings, right? To go into the recordings first.
Yeah, that was a brilliant plan.
Brilliant plan. Yeah. It was Julie's idea.
Good job, Julie.
But, man, it made me nervous.
So we'll kind of get into that here in a second. So, one of the things that they teach you in law school and at CLE and stuff like that when you're dealing with juries is this idea of having a theme and a theory, right? And to kind of beat that into your jurors' heads, because when they go back into that jury room for deliberations, you want them to recite your theme, right? And recite your theory and know, like, this is what they were trying to prove to us. And we spend, when we're dealing with juries, a lot of times on theories and themes. And what do we bring in? What do we pull out? How do we make this as nice and neat as possible? And so, who thought of the theme here? It
was me. But Christina's going to take credit for it.
Whatever, Floyd. So our big things with her were alienation, and then it was drugs, and it was the fact that she had moved, right? And so those were like the 3 main points that Floyd was going to beat down throughout the trial, right? And so Floyd was kind of struggling with, how do we present this?
And then Christina came in to save the day.
Per usual. And so we came up with Dad, right? So it was distance, or first we started with drugs, alienation, and then distance. And so as he's going through and he's presenting the case, everything was related to dad, right? Drugs, alienation, distance. And anything that was not relevant to either or any one of those issues, we didn't discuss, right? And so, and the judge later complimented us on the theme.
Me?
Well, he told me separately, but
Oh, okay.
I didn't tell the judge that I thought of it, by the way.
Okay, right.
But he really loved your theme. He said it was excellent, and the way that you kept going back to it during the jury trial, he said it was very simple. It's just dad, 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 everywhere you went. So you go in, we develop the theme, you present the theme, and we start with the drugs.
Well, so first let's talk about the voir dire.
Okay.
So the purpose of voir dire is to get favorable jurors, right? And my first question to the panel was, who believes that children should be raised by moms rather than dads? And I don't know.
Everybody raised their
Yeah.
hands.
Yeah,
It's like,
at least
what?
95% of the panel. I was like, oh man, this is not going to be good. This is going to be rough. But we were able to, because we couldn't strike everybody.
Right.
That was difficult. And so I had to spend a lot more of my time on voir dire on that issue because, like you said, it's conservative. Kids are young. And so the predisposition is they should be raised by mom. And so in addition to all this other stuff this attorney's created for us to overcome, we have to overcome that predisposition as well. So
Yeah, that
I thought we were shot. I thought it was over.
Yeah, he called me on a break that morning. I was like, so how's it going? He's like, everybody thinks these kids need to be with mom. And I was like, oh, no pressure. You got this. Have fun. And so you go into your opening. We work on the theme. And then I think one of the biggest things that we had to overcome were these recordings. That's what we were talking about.
Right, yeah. So there were a few recordings where mom had recorded dad being verbally aggressive. So there's no physical violence, but there was some name calling.
Some ugly yelling.
Some ugly yelling,
Yeah.
yes, for sure. And that was the biggest thing we had to overcome evidentiary-wise, right? We knew that was going to affect the jury. So then Julie had this great plan to let it out first and own it, which ended up being brilliant.
Yeah. So there's a kind of a theory that a lot of attorneys exercise, and that's kind of taking the wind out of their sails, right, of the other side sails. And so that was kind of jury's thing. And I think this was decided, jury's trial started at 8:45, and this was at around 7-ish.
Yeah, 7:30. We were at Starbucks finishing up everything.
And I get a call, and they tell me, and I'm like, what? No, what? And then I kind of start thinking, I'm like, well, gee, why not? Like, maybe. I think this might actually work. And so I was like, do it. Let's just, I mean, they're going to hear it, right? We knew that opposing counsel, because they had proffered it in discovery, there had obviously been discussions beforehand. We knew that they were going to disclose it. So I was like, let's just play them. And so
It was certainly a high risk, high reward gamble there. Yeah.
but you put them on the stand. You talked about the drugs, right? And so I think you had some photos where mom had been passed out on the floor.
Dad had to come home from work one day to take care of the kids. Dad came home one day and found her passed out on the bathroom floor. The car accident with the kids.
But see, here's the thing. So all of that, it was compelling, but it was also concerning because all of that stuff had happened, and then he agreed at a temporary hearing that these kiddos would stay with mom, right? And so anytime you have those types of circumstances, it's important that you're at least litigating those issues and not agreeing to them, because it's kind of like, well, if you didn't care about that at a temporary, then why should we as the judge or jury care about it now, right?
Right.
And so we had the drugs, and then we had the alienation.
Yes.
So you talked about the whole visitation issues and, all that crap that she had been doing to him.
Right. Yeah, not showing up, not letting him have Christmas, not showing up for exchanges. And when he goes up there, he gets 20 minutes, that kind of stuff.
And then the last one was the
distance, right.
And just kind of the difficulty that it created for him to be a normal father. And so talk public policy with regard to GOs.
Yes, public policy of the state of Texas is to ensure that both parents maintain close, continuous contact with the kids. And that's typically done through a geographical restriction. So generally in this county, it would be Midland or Midland and contiguous counties, so Midland and surrounding counties. That way everybody stays close, right? And so the parent that is not the primary parent or managing parent can still go to all the extracurricular activities, go to school events and things like that. When you're 12 hours away, it's hard to run up there and watch a school play, right?
Right.
So things like that. But that's the public policy, is to make sure that everybody's close together. But in this case, the temporary hearing screwed us up.
And so did you go, Dad, and then you said, I think we anticipate that these recordings are going to be played, and so I want to kind of walk you through them after you did all that?
Yes.
Okay.
Yes.
And so how did you present it?
Basically, just like you said, right? So, and basically, like, you're not completely innocent. You guys got into arguments. There was some words exchanged that probably shouldn't have been exchanged. And of course, he apologized and felt bad and all that for what he said to his wife at the time.
But you played the recordings, and then you had him explain the context of the recordings,
Correct.
right?
Yes. Yes.
And so that way the jury would kind of understand, like, oh, well, you know, maybe if he just found out that she was smoking weed and the kids were there, maybe he was warranted in yelling at her the way that he did. And maybe not necessarily providing justification, but an explanation as to what was being played and providing context, which I think was
Right.
huge.
That wasn't handled incorrectly, probably, right? But is there an understanding as to why he said some of the things he did? Kind of.
Right. So then it goes over to cross. And so in a trial, if it's bench or jury, we get to call our witness, then we pass it to the other attorney, and then that attorney gets to cross-examine. And what does the attorney do on cross-examination?
She plays all the damn recordings again. They were, I don't know, 45 minutes long or an hour long or something. And she played them all again on cross.
Yeah. And I think that was, I think it blindsided her, the fact that you played them first. And I think it probably would have blindsided me too. I would not have anticipated that.
It was a very risky move.
Yeah, yeah. And so I think when she had prepped for the trial, she had prepped her cross, she had prepped to question and play those recordings. And so she went ahead and she did it again. And again, going back to understanding your jury and making sure that it's entertaining, that was, I think, something that kind of frustrated the jury. Just, you said that they were kind of like leaning back in their seats and they were kind of like throwing their head back, like, okay, we get it. So maybe not the best move.
No, and fortunately for us, right, we had another associate, Julie, was there with us. We also had Gretchen, our paralegal, there. And so I had the great fortune to have them there. They could focus on the jury and tell me how they're feeling, looking, and thinking, while I was focused on the questioning and objecting and evidentiary stuff like that. So that was a benefit that we had. And so on all the breaks, or if they saw something, they'd pass me a note, like, hey, the jury's getting frustrated with this, move on, or whatever, right? And so in this case, yes, they were able to watch the jury and see that the jury was getting frustrated with the recordings being played a second time.
And so then we call Mom, right? Did you call her in your case in chief?
No,
No?
I did not call
So
Mom
who
again.
did you have? You had John, and then who were your other witnesses? Was that it?
That was it.
That's crazy.
That was it.
I mean, but there was nobody else,
There was
really.
nobody else.
Yeah. And so we call John, we rest, and then she calls Jane, and that was fun. I think cross-examination is like the most fun part of our jobs. Yeah?
Yes, yes. I tell all the clients before we go to trial when I'm prepping them, like, look, cross-examination, it's our bread and butter. Don't mess with us on cross. You will not win. Like, cross is fun. Direct, anybody can do a direct.
Right.
Cross is fun.
And so she gets on, and she, I think, made some allegations of family violence against our guy,
She did. Yeah.
right? What else did she say about him?
That he was controlling, that he would not, like in one of the recordings, he has her keys, that he wouldn't give her the keys to the car. Of course, the jury had already heard that that's because she was smoking weed. But he controlled the mail, like locked down her credit cards, that kind of stuff.
Okay. And did she admit that she had smoked marijuana?
No.
She lied about that?
She said she had smoked marijuana one time in the summer.
Okay. All right. And what did she say about her just absconding to Colorado? Like, was she afraid for
She
her
was afraid for her
safety?
safety, yes. He had
Okay.
guns and he was violent and
Okay.
all that. And mind you, there'd been no police reports, no family violence allegations before, nothing like that. So
And so then you get her on cross, and we've said this before, I'm going to say it again. Don't lie on the witness stand. Don't lie to your lawyer, please. But she makes a very, very stupid decision, and she lies on the witness stand.
yeah, so she lied a couple of times. One of the times I couldn't really affirmatively impeach her, right? So she had lied about using drugs. And we had gone through and found some bank statements where she had taken cash out at an ATM at a pot store in Colorado. There was a couple of those occasions, $200 or something. And she said that she didn't buy pot with it. She acknowledged that the store only accepted cash, and she withdrew the cash from that store, but they didn't buy pot with it.
It was just convenient. She was
Right.
driving by.
She was driving by, and she just happened to pull cash out right there. And then the pot that she did admit to smoking, she said that actually our client had bought it for her several months prior and then ended up making her smoke it on that day. But that was the only time she had smoked.
Our producers, like, yeah.
Yeah, these were
That was the
statements.
story.
These were statements made on the stand. And so, although I couldn't prove any of that was untrue, I could kind of walk through the line of questioning that made the jury realize that she's.
Like that face that was just made? Was
Yeah,
the face
that was
of
the face of all
jurors?
the deniers, yes. So we had that where we could kind of trip her up and make her just look ridiculous for those statements.
Yeah. But then you busted her on a big one.
Then we got a
right?
big one, yes. So when we talk about denying possession, she had denied a Christmas holiday, and she testified that so they were supposed to exchange at like 8 o'clock in New Mexico or something. I don't remember the exact time, but and she said, you know, the kids got out of school at 3. There's no way she could make it by 8 o'clock or whatever it was. And so she would meet him the next day. Well, my client was there on time, and then he ended up having to go to work, and so we had somebody. He had designated somebody else to do the exchange, and I'd gotten with her attorney and all this stuff to make sure that we got a visitation. It was a whole mess, but she got there like 4 o'clock in the morning. It was crazy. But anyway, the point is that she said all of that was because her kids were in school, and then she talked about how she had gone to their holiday parties that day and dropped them off because I walked through timeline on that day. But what she didn't know is that I had the attendance records. And the kids were not actually in school that day. They were absent. And so after I walked her through that entire day of everything she did with the kids at school and all that, I got to show her that they weren't really in school. And the jury wasn't pleased.
And so here's the thing, is when you're a witness.
Neither was her attorney. For the record, she didn't know.
When you're a witness, or more specifically when you're a party, and you lie on a witness stand and you get caught lying, what it does is it negates everything else that you say. And I think that there may have been some portions of her testimony that the jury could have believed, and probably did believe. But once that happened, it was like, if you're going to lie about something so silly, like, what else are you lying about, right? And can we really believe that there was family violence? Can we really believe that your husband made you smoke this marijuana? Can we believe that you had to flee to Colorado for your safety because you were worried about guns? I think, in my opinion, it negated all of that crap. And at that point, the jury was like, you're done. Like, we don't.
Yeah, I tell all of my clients before we go to a hearing, like, I could fix almost anything that comes out except your credibility.
Right.
If you lie to the court, we're done. Just
Right.
sign our names, let's roll out.
Right.
So.
Right. And if you lie to us, right, and same thing, I think that pretty much anything that clients tell us we can figure out a way to mitigate. I don't care how bad it is, but we have to know about it. And if you don't share that information with us and I walk into a courtroom and I get kicked upside the head with it, you want to piss me off, that's a surefire way to do it. And so, because I can't help you at that point, and really all you're doing is hurting yourself because I can't do my freaking job.
Yeah, and we've all been there, right? We've all been blindsided in court. You're like, what the hell, dude? Like, and this poor attorney was there that day, and I felt bad for her.
Yeah.
She had no clue.
Yeah, but I'll typically just maintain my cool, like, yes, I knew that was coming, Judge. And then,
until we get outside.
Yeah, exactly. And so, so then from there, so she lies, we go in, what else happened after that?
I think that was it, right? I think we just closed.
And then you called me, and you were like, I was like, how did it go? I think, what did you say? I think you felt pretty good after it, but you didn't know if it was going to be enough. So here's kind of the thing. And so I guess we probably should have started with this. And that is that what we were requesting was the exclusive right to designate the residence. So we were requesting that these kiddos live with dad, and that also the geographic residence be restricted to Midland and contiguous counties. We kind of felt like we could probably convince a jury to make mom move back. I think that was kind of where, like...
That was our goal.
Yeah, there's maybe like a 50-60% shot that we can get that done. We didn't think that we would actually be able to win primary conservatorship for father because, like we said, when mom was up in Colorado, for the most part, things had been going smoothly for the kiddos other than the visitation stuff. And so...
And dad had already agreed to give her primary.
Right. And so jury deliberates, you call me, and you're like, I think, it went well. I think that, they're probably going to make mom move back, and we kind of talked through everything that had happened. How long were they out deliberating?
6 hours, I think. 5 hours.
And they came back with a question.
What
Was the question?
Oh, God, I don't remember. But I remember after reading the question, I'm like, yeah, mom's going to be primary. We're going to get the GO. But it was something like, It was something about the geographic restriction. Can we do a GO and name primary or something like that?
Yeah.
Does it have to be the same or something along those lines?
Yeah. And so they asked the question, gets sent back, and at that point we thought, okay, mom's probably going to keep primary, but she's likely going to have to move back to Midland. And so and then they come back, and what happened?
They gave dad primary.
Crazy town.
Yes.
That was a good day. That was a
very,
good day.
It was a good day.
And so he gets primary. He's limited to Midland and contiguous. Mom gets standard visitation.
Pays child support
because remember, we had to go on all those issues to the judge. So judge orders standard, judge orders child support. Exchange location is...
in Midland.
So she has to come and pick up and drop off in Midland. And so overall, it was a very, very good outcome for John. And I think that's like my second favorite. Do I think my first favorite? My second's cross-examination. My first favorite is when we meet people like John, and he comes to us, and he has no hope. He's just feels completely screwed by the system, by his attorneys, by his wife, worried that he's never going to be able to be a real father to his kiddos. And we're able to take this person and help them, achieve their dreams. And that was to be able to raise his kiddos and to be a good dad and to have his children, close to him. And so, and he's doing good, and the kids are doing good.
He is doing great, but that did not come without fights between he and I, right? That's part of the process. Mm-hmm. It never happens quick enough, and I understand, right? But you have to have that. Do you want it quick or correct, right? And just trust the process, and we'll get it done. But he was frustrated several times throughout the case, as were we. But at the end of the day, he got what he wanted, so I think he is happy.
Yeah. And and that's the other thing. Like, I've always had that where clients they have to kind of give in to us and what we're advising them, and really, really put a lot of faith and trust in us. And they have to have the ability to follow what it is that we're saying, which is not always easy. But 9 times out of 10, if you guys do that, then you're going to have great things happen. It's the ones that fight us along the way and then finally just say, we're not going to do this, that we have major issues with. And so, but yeah, I mean, John has his kids now. Jane's none too pleased. But I mean,
Raising a bunch of hell since.
Yep. So, but yeah, jury trials, they're expensive, but obviously great things can happen. And in this particular case, I do think it was absolutely the right move. I do think that even the judge probably would have made mom move back to Midland County after hearing all that stuff. But I think he would have said, Mom, you're going to keep primary, you move back to Midland. And so we got something, I think, better than what we likely would have received from the court. So, and that's when you do a jury trial, right? So, as we always say during the context of this podcast, don't follow our advice. If you find yourself in this situation, please go and hire a local attorney. Talk to them about your situation. Follow their advice. This is just really for general information. And always, please like and subscribe. YouTube, TikTok, Instagram, Facebook, any social media platform that you can find us. Please follow us, and hope you guys have a great day.
Bye-bye.